frequently is people that have first go into assisted living facilities and nursing homes. They come to us with these agreements and contracts that are 40 pages long, a big personal for Hills. And they go, what does this mean? What should be in here? What should not be in here? So Dan is out here going to talk about those topics.
Good afternoon, everyone. We made it. So you'll note we skipped the presentation. We're going to skip over Medicaid recovery, which is apropos, because before you get to recovery, presumably the resident has already signed a long-term care contract. So the purpose of our presentation is to focus on the contracts themselves. People come to us often asking about long-term care facilities, as if the term refers to a single kind of institution, which it does not. There's various kinds of care facilities, each with their own legal and regulatory frameworks. So for instance, what's required at admission, the payment arrangements, the accessibility to government benefits like Medicaid, all differs depending upon the kind of facility that you're dealing with. But the bottom line is that regardless of what kind of facility is at issue, you're dealing with a contract. And the terms of that contract dictate the rights and obligations with the facility and the resident. And so today, we're going to highlight some provisions that we come across often so that if you encounter a long-term care agreement out there in the wild, you know what to look out for.
As Dan had mentioned, can you hear me? Is this right? As Dan had mentioned, oftentimes clients or potential clients come to us. They say, hey, I have a parent on a loved one going to a nursing call. Will you review this admission agreement for us? And oftentimes people confuse the terms, right? Nursing home, assisted living facility, other types of long-term care facilities. So before I give any guidance, I want to say, let me look at the contract. Let me review what the contract says, especially if I don't know the facility in question. We're going to get started with assisted living facilities because assisted living facility more than that better. See, people said they hurt. Assisted living facilities can get away with a lot of things that nursing homes cannot get away with. That's because federal regulations actually, a lot of Medicaid regulations kind of control what nursing homes can or can't get away with in comparison to assisted living facilities. First and foremost, if someone comes to me with an assisted living facilities admission agreement, I'm looking for one big glaring word or words, and that is guarantor or responsible party. Sometimes assisted living facilities call a power of attorney or a guardian, a fiduciary, a responsible party. And if you read the definition of responsible party that's contained within the admission agreement, you will be able to tell whether they're referring to a fiduciary or whether they're referring to someone they are going to try potentially and hold out as a third party guarantor. Or okay, that could be very problematic. We'll talk about that in a minute. But the big sort of subject matter of my review when it comes to assisted living facility agreements is the guarantor understand they were they not take. I mentioned that the guarantor language is especially problematic for assisted living facilities because of their Medicaid addendos. Many assisted living facilities, unlike in nursing homes that accept Medicaid, can condition the admission of a resident or a prospective resident on that prospective resident's ability to pay privately for a period of time. Sometimes that's 2 years. In fact, Goldblum Autonomous, most assisted living facilities in this area will ask you for 2 years of private pay before converting to Medicaid. But more recently, we're seeing assisted living facilities that require 3 to 4 years or more. And so if a prospective resident or a resident gets to their 2-year private pay commitment and they no longer have funds available to pay for their care or stay in the facility, they've spent from the cost of midday. If there's guarantor language in the admission agreement, that fiduciary, that power of attorney, that love, and that family member who signed as a guarantor as the responsible party is now live up for $11,000, $12,000 a month. So, and it can put families at risk of really financial catastrophe. And so we want to look at the Medicaid addendums. We want to see how long Friday pay is respected and what sort of guarantees, oftentimes no pine guarantees, but what sort of promises are we about if the American regular Medicaid get organized? I don't know.
Okay, so a continuing care retirement community, or a CCRC, it's a different kind of disability that presents different contractual challenges or still to be out. In principle, a CCRC is a facility that offers a continuum of care. So a independent living, assisted living, memory care, skilled nursing, all in one place, which is attractive, particularly for couples or people who want to remain in one place while having the ability to progress to varying levels of care, all in one place. Typically, residents enter at the independent living club. They get the private apartment, an extensive host of amenities that are available. And unlike nursing homes and assisted living facilities, CCRCs are much more loosely regulated. There are continuing care statutes, there are licensing requirements, but for the most part, the relationship between the facility and the resident are dictated by the terms of the contract itself. And so, at CCRCs in particular, is important to scrutinize those terms. One of the primary features of a CCRC agreement is an entrance fee, which is a substantial upfront payment. That payment is pooled together with all of the other entrance fees that have been received by the facility and invested. And using that income, the facility kicks forth its own operations. And as a result of that model, the monthly fees that a resident pays are comparatively much lower than those you may find at a assisted living or a nursing home. So it sounds rare, but there's inherent risk involved. Particularly, CCRCs generally will condition the residents' ability to stay at their facility on their ability to independently fund their care and their stay. And to that end, they do not accept Medicaid. And if you exhaust your assets as a resident, your options are fairly limited. Some CCRCs offer financial assistance programs or charity funds, which require residents to demonstrate that they have no other available source of funding and to be completely transparent with regards to their financial information. And I guess most importantly, not to have dissipated their assets either through the funding of a trust or gifting to a family member during the entirety of the residence. It is discovered during the internal audit that the CCRC conducts that they've done something like that. They could be disqualified and may be told that they need to find somewhere new to live. Here is the big one. Refund provisions at CCRCs are something that each facility has variety. And so you have to look out for the nuances of the provisions that you see. CCRCs market the entrance fee as being up to 90% refunding. The catch is that it's generally not that simple. Upon a resident either passing away or vacating, you're told that you can get up to 90% if you refund that. But in reality, typically the refund is conditioned upon a unit being pre-rented and the facility receiving a new entrance fee from a new resident. And that doesn't happen right away usually. Sometimes it takes some time it could take months, it could take years for a new resident to come into possession of the unit for you to receive your refund. And so I provided a couple different examples. I don't know if they're legible, but I'll describe that in general. So these are real life examples pulled right from contracts that we've come across. In one, I'm not sure which, they require that your unit, your exact unit, be re-rented before you receive a refund. And all the while, it is the facility that controls the pricing, the marketing, all of the showings for the unit. The provision does not set any deadline by which the unit has to be re-rented. And the facility has no obligation to prioritize one unit over any other. And so, in essence, the ability for you to actually obtain a refund is completely within the discretion of the facility. I don't know if it's legible, but I've come across other examples, for instance, where upon a resident either vacating or passing away, they or their family will be assigned a number, and they then join a queue. And so, for instance, if you're number 7 in the queue, 7 other units need to be re-rented before you get your refund. And so your refund is conditioned upon the facility's ability to continue attracting new residents, which isn't always the case.
I would say that's the queue model is most common. But Dan had a case recently, I think involving a family who was waiting 3 years, 4 years, for the specific CCRC to actually re-rent the specific unit. And so the CCRC was holding on to hundreds of thousands of dollars. And people die, that an estate winds up with money, and it just becomes very confusing.
In that case, the resident of the CCRC was deceased. And so this is the only aspect of the estate that's yet to be administered years after this gentleman passed away. So there are real risks involved, and it's not a guarantee that you'll have a victor refund. That needs to be made clear before considering this kind of facility. The most present risk with regard to your entrance fee is the prospect that the facility goes bankrupt, which, as you can see, it happens more often than I think people would like to admit, and more often the facilities themselves are obligated to admit. So facilities have no obligation to prospective residents to disclose whether they've previously declared bankruptcy. And the last 6 years, 15 have done so. The issue is this: your entrance fee is a lot more than like a interest-free investment into the operation of the facility. So if the facility is facing financial hardship or goes under and declares bankruptcy, you lose. So the financial risk involved is basically borne by the president. Just as an example, a couple of years ago on Long Island, a CCRC called Harborside declared bankruptcy for the 3rd time. And those residents, some of whom were over 90 years old, had paid over $900,000 for their entrance fee. And at that stage in their lives are told, you got to find somewhere new. So the risks are significant, and they need to be carefully considered. Go ahead.
One way to overcome potentially those risks, especially the bankruptcy risk, is to ask a prospective CCRC whether they've undergone a financial audit recently and ask them for that data. So CCRCs are more transparent and going to be the results of a financial audit. It's really useful in making a decision about whether a potential CCRC is worth risk. Others will not be so transparent, and that should guide their decision.
Just to piggyback off that, for instance, some CCRCs will declare bankruptcy and then change their name. So they're very creative, and there's limited ways as a prospective resident that you can find out this information beyond what Donnie suggested. So in some CCRCs, they're great in a lot of ways. They give you an opportunity to remain in place, to have a kind of all-inclusive community that you can live in. But they come with really significant financial risks. And for people who require a high level of care but lack the assets, the only option is for them to see Medicaid, in which case you're likely looking at a nursing home. And nursing homes own with their own contractual rights and obligations. That we'll discuss that too.
As I mentioned earlier, nursing homes, skilled nursing facilities are some of the most regulated forms of long-term care facilities, and they are largely regulated because of Medicaid and especially nursing homes that accept Medicaid. However, we still run into nursing home admission agreements that sort of violate a lot of the federal and state laws that are in place to protect the consumers and their families. As these are some of the key issues that the spot for when reviewing a nursing home admission agreement. Unlike assisted living facilities, can condition admission on a prospective resident's ability to offer a guarantor. Can't condition admission of prospective resident to based on their ability to pay a set period of time before converted to Medicaid. But there are also some sneaky sort of provisions that wind up in these admission agreements. One is limiting the statute of limitations on certain claims. Sometimes a person who sustains an injury in a nursing home may have ordinarily a 6-year statute of limitations to pursue a claim against the nursing home. We've seen in admissions agreements where the parties agree to limit the statute of limitations to just 1 year. So we want to make sure that we remove those terms or negotiate those terms out. I would say 9 times out of 10, we encounter binding arbitration agreements in the nursing home admission agreements. We don't like binding arbitration agreements for many reasons. The arbitrator is selected by the nursing home itself. And so we don't really trust that arbitrator, right? But also, imagine if we have a nursing home resident, and no offense to certain people in this group, but a little old man, sympathetic little old man, in a nursing home, and you want to hold that nursing home accountable for an injury sustained in a nursing home. Do we want our fates to be submitted to a arbitrator or a panel of arbitrators, or do we want to send those names to a jury? Right? Do you want that trial ledger? If you have a binding arbitration agreement, they're effectively weighty the rights to a trial ledger. And so we want to make sure that we're negotiating that has deep great in theory and contains binding arbitration agreement. Also, just as a PSA, we now have the ability to write out or revoke the binding arbitration agreements, yet they were signed as part of the initial admissions package, so long as you revoke the binding arbitration agreement itself within 30 days of entering into the admission agreement. Financial disclosures. Many facilities require 5 years of financial disclosures at admission. Those are difficult to overcome. The facility wants to make sure that you have gifted a tremendous amount of your assets and, in other words, not qualifying for Medicaid in the time amounts. We've seen some nursing homes charging interest rates on unpaid bills that amounts to usury. So we want to look for those provisions and write those out. And then obviously, a level of care, you always want to make sure that the nursing home that above to is capable, is able to provide the level of skilled care that they need if they're going into the nursing home. If a nursing home agrees to accept a resident after a clinical review and assessment of that resident, they have to keep the resident. They can't turn around and say 2 months later, 3 months later, oh, their level of care is too high, can't provide those services. Under federal law and state law, the nursing home has a resident in their bed who they accepted in the past, they have to provide the care and services needed for that resident. So,
Hey, dude, that was very big. And Anna has to get to the airport to grandson. Thank you all for attending. We have lunch. I saw some people taking pictures of the slides. All slides will be available on our website. And we will circulate that to all the attendees so everybody will get the slides or get all the information. So enjoy. Lunch is already ready. So I appreciate coming. I appreciate the stay, and we look forward to more exciting topics next year.
The